Chapter 11 talks about pre-employment testing, and we've touched on this a little bit in earlier chapters. If you look in the textbook on page 214, they list a lot of the different types of common pre-employment testing. The general rule is, and this is very consistent, should sound very familiar, if the testing actually measures a legitimate skill or qualification necessary to do the job, then the testing will be allowed. It would not be deemed to be discriminatory, even if it had a disparate impact. So if we are discussing pre-employment testing with an employer and they want to make sure they're doing it legally and not going to create issues for themselves, that's going to be our main advice. Make sure that it is actually measuring a skill of the job, because the legal concerns, of course, are what we've already talked about before. Disparate impact is the more typical case we see with employment testing. So going all the way back to the case at the beginning of the semester where the company had different departments and all African Americans were working in one department, and then when they were opening it up, they put a requirement that you have to have a high school degree or diploma, and it turned out that in that community more African Americans than other races did not have that, so it effectively kept them out of the job. When the employer was challenged on it, they could not show that having a high school diploma effectively measured the employee's ability to do the job. So the disparate impact is always key. We also talked about the airline case where women were entering the workforce in the airlines with the behind the scene and the baggage handling, and they used to have requirements that you had to be 6 feet tall and 200 pounds, which effectively meant most women were not going to be qualified for the job and be able to be hired, but that wasn't measuring an actual skill of the job. It was their ability to be able to lift so much weight. So the lifting of weight, if it's 50 pounds and more women than men cannot lift 50 pounds, if they can show lifting 15 pounds is a requirement of the job, then it would survive a discrimination claim. So disparate impact is our main concern. You can certainly have disparate treatment in cases. Those tend to be more where employers just have certain people take the test and do not uniformly and consistently administer the test. And you also sometimes have issues with the fact that the employer is intruding into an individual's non-employment affairs. So when does the employer overstep the line and cross into the employee's private life? When, if ever, are they able to do that? And we will talk about that more in Chapter 16 at the very end of the semester. Okay, so basic types of tests. Cognitive tests measure basic skills and skills relevant to the job. So that could be an actual intellectually based test. It could be writing skills. It could be typing speed, anything along those lines. Strength tests, the ability to lift, to stand, to bend, if as long as required by the job would be appropriate. And then psychological and personality tests, which we probably see less of those in the workplace, and certainly in some higher level positions you tend to see that a little more often, higher level management positions. So what the employer wants to do to try to ensure that any test they implement is going to be legal and valid, first and foremost, administer the testing uniformly and consistently, as I just mentioned. So if everybody applying for a certain type of job has to take the test, that's going to certainly help the employer. It still could be a disparate impact case, but you're definitely going to avoid disparate treatment cases. So, and the employer does not have to make every applicant take the test. They can certainly whittle down the applicant pool to those applicants they feel are most qualified, but then once they get that smaller pool, that's when they have to uniformly and consistently apply the test. Secondly, what we've already talked about, ensure the test actually measures a business necessity, so an actual skill to do the job or qualification to do the job, and make sure that the testing is narrowly tailored to measure the minimum skills necessary. So sometimes courts have had issues with employers who have tests that are measuring skills, but they're measuring at a much higher level than what is necessary to do the job. So if you need somebody to type 60 words a minute, but you're requiring them to type 80 or 90 words a minute, that might be open to challenge if the right plaintiff comes along. So we want to make sure that it's not just the skill that's being measured, but the level of proficiency at that skill that is being measured is what is necessary to do the job. So some other common background checks and tests, which are a little bit more interesting and probably a little bit more controversial for a lot of us. The reason an employer wants to do appropriate background checking is to avoid a negligent hiring claim. This would be the type of claim where somebody, and it could be an employee, it could be a customer, a client, a vendor, but somebody sues an employer for harm that was foreseeable, that was caused by an employee that was not fit to do the job. So we tend to think of this more with people operating heavy machinery, that type of equipment, or it could be in a hospital setting, a medical setting, where people could really do damage if they don't know what they're doing. So the employer definitely wants to ensure that they have a safe workforce, not just for their own employees' sake, but for anybody who comes in contact with those employees. Because if they can show the employer did not take reasonable measures to ensure the employee was qualified to do the job, and that employee turns around and injures somebody or causes harm, the employer could be sued. So employers want to avoid that. So some of the common background checks that get used. One is the criminal background check. In Pennsylvania, we have the Pennsylvania Criminal History Record Information Act. This act specifically allows for felony and misdemeanor convictions to be considered in the employment decision-making process. Now, there is a limit in the law, and you can see in the materials that the convictions are only supposed to be considered to the extent to which they relate to the applicant's suitability for employment. But that language, quite honestly, is pretty vague, because I think employers could very often make an argument that a conviction relates to an employee's applicant's suitability for employment. So this is a tough one for some people, because it can be tough for somebody who has criminal convictions to find employment when it is easy for the employer to not have to consider them because of the conviction. So how do you prove yourself to be a good employee, to have to be rehabilitated, to not have whatever concerns or issues there were in the past, to not have those exist now? It becomes very, very difficult. So people who are in that situation or know people in that situation really tend to struggle with this. The employee or the applicant certainly could make an argument that it does not relate to the applicant's suitability for employment, but I would think, especially if it was any sort of violent crime or any sort of crime that involved dishonesty, fraud, anything along those lines, I think it would be very easy in many, many jobs for employers to say that particular conviction relates to their suitability for the job. So it can be very difficult for people who have those convictions. What is supposed to happen? And I can't say that this does happen. I know in past years when I've talked about this, people who have been in the situation or know people in the situation says this doesn't happen. But what should happen under the statute is, if the employer is not hiring someone because of a criminal conviction, the employer is supposed to notify the applicant in writing in accordance with the statute. So again, that may not happen, but that's what's supposed to happen. So a couple things just to make sure you're really clear on. One, this is convictions. It is not arrests. So it has to be a conviction. And usually a conviction can be an actual trial conviction, or it could be a plea agreement conviction, but it has to be a conviction. The statute does allow an employer to use an arrest as a reason not to hire someone, but they have to be able to show there is a connection between the charges that have been filed and the employee's ability to do the job. In some cases that will be easy, especially if it's a safety or security type of position, but beyond that it might be more challenging. But because just an arrest is usually for a very brief time frame, because they're either going to be charged or they're not, you're likely to see more of an issue with convictions. Now, there are some other laws that deal with convictions. For instance, people working with children, they obviously, they have to be conviction free, and it doesn't really matter what kind of conviction it is. But so there may be jobs where there's other laws that apply separate from this, but criminal convictions can be used. Another one that also is fairly controversial for some people is the credit check aspect of the employment relationship. The Fair Credit Reporting Act, which is a federal law, does allow for employers to use credit reports in employment decisions. So not just the hiring decision, but at any point in time in the employment situation. So what the employer has to do in order to be able to use somebody's credit report for an employment decision is provide written notification to the applicant or employee and obtain written consent from the applicant or employee that they may check their credit report, and then they have to notify the person if an adverse employment action is to be taken based on the credit report. So this can be used for an existing employee. In theory, the employer could just run a credit check on an existing employee and fire them for that basis, but they have to provide notification and get consent. One of the ways that employers can easily get consent, which we just talked about in the previous chapter, is on the application having having as part of the what the employee is signing off on when they either actually sign the application or submit, that they are consenting to this type of background check. And so that would be a very easy way for the employer to get consent. For an existing employee, might be a little more challenging, but a lot of times when we start new jobs, we're signing a lot of paperwork, and sometimes that could be in a disclosure form. It might be in an employee handbook, and then when you sign the document, I have received and understand and agree to follow by all policies in the employee handbook. If that is in the employee handbook, you've probably just consented to it. So it's not that hard to get consent. And of course, the issue is if you don't want them to look because you feel it's invasive, not necessarily because you have anything to hide, but you just feel, why should my employer have that information and be able to access it? If you're an applicant and you say no, then they may not consider you for the job. So there definitely is unequal bargaining power when it comes to this one. And again, the employer is supposed to provide written notice of any adverse employment action taken based on that. And the law itself in this particular act is unclear whether the credit check has to be related to one's ability to do the job. So for instance, some people say, well, if I'm going to be working in a bank and I'm going to be handling money, then maybe the credit check is appropriate. However, having bad credit doesn't mean you are going to steal money or be tempted to steal money. So I personally have some issues with it, but it definitely is allowed. An employer, with both the criminal background check and the Fair Credit Reporting Act, employers do not have to perform these background checks, but they are allowed. There are some constraints, but it does tend very much to favor the employer and not the employee in these situations. Another common background check is, of course, the reference check, which we've talked about in Chapter 10. It is always in the employer's best interest to do reference checks. They may not always get the kind of detailed information they want, but it usually is still in their best interest to do them. Another potential test that can occur is the polygraph test. So there is an act, a federal act, that deals with these. Generally, they're prohibited in the private sector. So for most jobs, no, your employer cannot hook you up to a polygraph test, whether you are an applicant or an employee. There are exceptions under the law. The common ones, and the ones that I think make the most sense, is security firms, companies that manufacture, distribute, or dispense controlled substances. So people, dealing with these types of issues usually can be polygraphed both before employment and sometimes during employment as well. Some employers will use the equivalent of, well, I shouldn't say the equivalent, but a form of lie detector tests that are basically pen, paper, or computer driven. You're not hooked up to anything. It's not measuring anything. It's just asking you questions and you're answering them. I had to do that for a job. It tends to just ask you a lot of questions, kind of in different wording in different ways, just to, kind of see if you get tripped up, and then there's a way to test it and score it. I don't know how good they are. Those do not fall under the polygraph test.